develop a relationship, Alpha Football Academy is one such body. You can develop a relationship and leverage, opportunities in this area. So this morning, I will invite the arrowhead of Alpha Football Academy in Nigeria to come talk to us for about 5 or 10 minutes about football. And in all of this, in the course of this presentation, I will want you to, be attentive and see how you can come in this whole, business of football. Please put your hands together for Alpha Football Academy. He will introduce himself and then talk briefly about his passion. Thank you.
Good morning, ladies and gentlemen. The day I got the invite to be in this conference, I said, Prof have put me in a very big dilemma. First of all was the fact that I was looking at what to put on because I was coming to a gathering where they're always suited up and all of that. And I'm coming from a place where we wear short and a jersey or tracksuit. And then I was saying, okay. The other thing was that I was coming to speak my little English that I understand, and the whole lot of people here, man. So I said, okay, how do I deal with these two things? So first I said, I'm going to pretend to be like one of them. So I went and dusted one of my suit and said, okay, if he comes, they say there's a young barista here coming to speak to them. And then secondly, for the language barrier, in the invite it was, come talk about the practical aspect of football business, the opportunities that abound in football business, but practically I say, thank God. So I don't have to come speak plenty English. I'll tell you real life instances and a whole lot of that so that it's easier for us to flow together. Good morning. My name is Dr. Abidemi Aregbe. I have a PhD in sports management. I'm not a doctor. First of all, in a couple of weeks, the academy, Alpha Football Academy, will be getting close to 500,000 euros from a boy I spotted on the streets roasting corn for his mother. One thing I'm blessed with is if I go to the football field, it's easy for me to identify talent. So he's a stocky boy. And then I saw the kind of job he was in. I said, okay, this one is staying under the sun for a long time. Yeah, so I went there, I bought the corn and I said, stand up, and he stood up. Wow. Yeah, I said, this size. Have you played football before? He said, I love playing football. I said, okay, where do you train? He told me. So I went to the field and I watched him. Honestly, after the day I watched him, I went to his brother. Luckily, I know the elder brother. So I spoke to the brother and I said, in a couple of years, you have a superstar in your house. It was like, okay, you don't understand what I'm talking about. So in a couple of weeks, when the transfer window opens, his name is Johnson Okpotu. He'll be moving to KV Mechelen in Belgium, and Alpha Football Academy will get in the tone of close to 500,000 euros. That's for the first sale. I'm starting with the juicy part of this business. There's a lot going on behind. I'll talk about that too. So, for 500,000, that's a lot of money. Now, there are people that are going to get percentages and all of that, including lawyers, from that amount of money. Okay, so that will bring me to the starting point of the academy. So, I used to be a football player. I stopped playing in 2013. I played in the NLO. That's the third division of Nigerian League. So I stopped playing. All from then, from my childhood, I wanted to play football. That's all I wanted. So when I stopped playing, I said, I still have to be relevant. I don't want to coach. I'll go into another aspect. So in 2014, I started a master's in sports management. And then that was it for Alpha Football Academy. I started Alpha not registered. I started in 2014 when I started sporting young ones, and then today they are doing well. Sorry again, one of my boys just came back from England, from Egypt, who couldn't secure a visa for him to move to Spain, but we're working on all of that. Now, so when we started, I have a knowledge of sports management. So there's this difficult part of grassroots football. When you go to pick a child, the documentation of this child is very important. You don't know from where he started playing. So at the end of the day, for instance, this deal that is about to go through for Alpha, if I didn't clear the boy properly using documents, then someone will come from behind tomorrow and say, this is my boy. You bring a picture where they snapped and all of that. But with your help, when I started, I didn't have money to pay a lawyer. We had a family friend. I spoke to my brother, bro, we need to do documentation and all of that. So he said, okay, let's talk to him. And we are family, but lawyers, he said, you know, football is big business. I know you don't have money now, so what will be in for us? So very simple. When we transfer any of this player, you get certain percentage. So if you are transferring a player for 400,000 euros, you're getting 10%, you're getting 5%, you're getting 3%. You've done your paperwork for us. That's your share of that money. So he said, oh, fine, we can start from scratch. So he was the first person that did a parental consent for me, that all of my words signed. That's big. I'm just talking about just the youth development side of it, football academy. It takes a long time. This is 10 years before I'm reaping my first hundreds of millions. It took 10 years, yes, but if the lawyer is patient, we'll walk the step, 10 years, and then we're all smiling to the bank. There are other opportunities. I know there's no time. I just picked this one because it's easier, and then you would find joy in it, honestly. When you see this, he came to the academy to watch the boys play, and it was all joy for him. So not just benefiting financially, you'll be happy to see these boys play. I'm just going to keep you with one quick one. Sorry, I just wrote this when I came into the hall. When I came into this hall, the theme of the conference was resounding in my head, because the biggest challenge facing sports in general, especially in this part of this world, is sports administration. It will be a great honor to see great minds as yours passionately come together to help put this lucrative business that takes vulnerable kids out of the street. Thank you very much.
Thank you. No, you just wait. Thank you very much, Alpha Football Academy. We're not just going to let you go. Colleagues are here. Please take his phone number. You give us your name and your phone number. There are colleagues here that may want to speak with you, either after this conference, or, either here or after this conference, or who may have a situation and we want to learn from your experience. You talk about first sale, second sale, third sale. Lawyers can come in as, advisors or compliance officers. So you need to have, they need to comply with certain documentation, for instance. That's where lawyers come in. Agreements, that's where lawyers come in. So our colleagues here can also tap from your experience in this area. So please, gradually, give us your full name. He holds a doctorate degree. And don't mind all this thing about wearing short knicker and not knowing what to do. He's a businessman. So thank you very much. Just gently give us your full name first. Just write it down somewhere.
My name is Dr. Abidemi Joshua Aregbe. Dr. Abidemi Joshua Aregbe. 070 33 3389. I'll take that again. 07033403389.
Thank you very much. We're grateful. Now, you just not leave. We have a tradition here. You take a photo shot for our record, with our dignitaries. So I invite Leonard Silk and our distinguished dignitaries, Chairman ICPC, Prof, members of council that are here, LOC members. Please, can we just come up here and have a snapshot with our friend who has come to talk to us, please? The photographer, just guide us through. Let's see. So you will take the phone number of the ICPC chairman, please. These are all players. So. Council members that are here, please, quickly, or judges that are here as well. Thank you very much. Thank you. We'll move to our first session on medical. Thank you so much. Thank you. I appreciate
it. Good morning, ladies and gentlemen. This is the fourth plenary. This is the first plenary for this morning. And today's paper is titled Interrogating the Boundaries of Consent in Medical Practice in Nigeria. There is no denying the fact that communication is central to the doctor-patient relationship. A doctor is under an obligation to see to it that he discloses all necessary informations before embarking on medical or surgical operations on his patient. At the same time, the patient has a duty to agree and consent to whatever medical services that may be rendered to him. This is very, very important. I'm sure the panelists will discuss the issue that there was an incident that happened here in Kano some 10, 15 years ago, the Pfizer case. The Pfizer people came to Kano without the consent. They administered drugs, and so many of our children died here in Kano. Some were maimed. The issue went to litigation, even up to the courts of the United States of America. This really shows the importance of consent of a patient whenever he is to be administered medically or surgically by a medical practitioner. This session will examine the concept of consent, verbal, written, implied, or informed consent in medical practice in the context of consent protocol relating to informed consent, consent procedures relating to incompetent adults, minors, illiterate patients, unconscious patients, consent in emergency situations, involuntary hospitalization, consent procedures during clinical trials and experimentations. This session will interrogate when a medical practitioner can lawfully withhold medical information from a patient. Okay. The chairman for this occasion is no other than Professor Mohammed Tabiu, Senior Advocate of Nigeria. A round of applause for Professor. This is his name.
So for the panelists today, would have some persons physically present and the others will join us virtually. We'll have with us Dr. Musa Adamu Aliyu, Senior Advocate of Nigeria. Please let's put our hands together for him. Dr. Musa is the former Attorney General and Commissioner for Justice, Jigawa State. He was appointed by the President and Commander-in-Chief of the Armed Forces, the Federal Republic of Nigeria. His Excellency Bola Ahmed Tinubu, as Chairman of the Independent Corrupt Practices and Other Related Offenses Commission, ICPC, on the 17th of October 2023. Please let's put our hands together again for him. You're welcome, sir. Please, sir, let's have you off stage. Thank you very much, sir. We also have one of the panelists, Abdullahi Mohammed. He is the founder and CEO of Oxygen Mats, Forbes contributor, lawyer. Mohammed is a writer, entrepreneur, lawyer, and he is a contributor of Forbes, USA Today, and he is here with us. Please let's put our hands together for him as he comes up. We also have, as one of the panelists here, Joyce Nena Seni Mrs. She serves as the Vice Chair, Medicine and Law Committee of the MBA SLP. She's the Head of Legal Services, Alex Ekweme Federal University Teaching Hospital, Abakaliki in Ebonyi State. She's a Research Fellow of the Center of Medical Law Research and Development. She is a member of the Nigerian Institute of Chartered Arbitrators, World Association of Medical Legal, Institute of Health Services, Administrators of Nigeria, FIDA, NBA, and AVBA. Please let's put our hands together for Mrs. Seni as she joins them. Thank you, ma. We have online, he'll be joining us virtually, Dr. Charles Kujo. He's an experienced Chief Executive Officer with a demonstrated history of working in the hospital and healthcare industry, skilled in epidemiology, emergency medicine prevention, healthcare management, strong entrepreneurship, professional with a postdoctoral research fellow focused in behavioral medicine from Harvard Medical School. It's online. I'm sure it's here. Yes, it's here with us. Thank you, Doc, for joining us. And last but not the least, we have here with us, we think we should also gain from his we have him here. So like I said, we feel we should gain from his wealth of experience too. He is a specialist general surgeon in the Aminu Kano Teaching Hospital. Because he's here, we think we should also hear him. So please join me as we welcome Dr. Ghazali Umar. Let's put our hands together for him. Thank you, sir. And the chair of this panel is He's already off stage. Professor Mohammed Tabiu SAN. He teaches law at Bahrain University Kano. He has been expert advisor on implementation of justice sector related programs in Nigeria for over 20 years. He is coordinating chairman of the Federal Justice Sector Reform Coordination Committee, Federal Ministry of Justice. He also chairs a technical drafting committee on national policy on justice. His areas of academic interest include justice and security sector reform, human rights law, Islamic law, constitutional law, conflict management, international humanitarian law, and transitional justice. Please again, let's put our hands together for the chair of the session. Leonard Sake, at this point, would hand over to you. Thank you, sir.
Sorry.
Hey, sorry, Chairman. Yeah, good. It's okay. Let's use another one. Kabashi, we'll use this one. Distinguished participants and panelists, I welcome you to today's session, which is also one of the important areas that are being addressed at this conference of the section on legal practice. I have with me the panelists who are all well qualified to discuss this rather specialized area of the law, which is relating to medical practice in relation to informed consent of the patient in the course of medical treatment. You know that under the law, doctors and other health professionals owe a duty of care towards Thank you. The doctors owe a duty of care in the course of exercise and treatment. Interventions. Should I use another one? And Dawood Shigaban. Oh, thank you. Okay. Thank you. So an additional duty to the patient, which is also related, is to give sufficient information to the patient and to obtain his or her consent before embarking on treatment. This is a very important area of the law for us at this conference for a number of reasons. One of the reasons being that it relates to our fundamental rights, particularly the right to life and the right to health. It also touches on human dignity and the integrity of the human body and other related rights. For instance, we can also say that it relates to our right to privacy, our personal autonomy, and so on. It is also a meeting point of various aspects of the law. These rights that I mentioned, some of them are constitutional rights. And in Nigeria, it is an area that is also regulated by legislation, and where there are set professional standards of practice. And in some instances, the issue of consumer rights have also arisen. It runs across the range of medical procedures, the issue of informed consent, maybe area of screening, examination, diagnosis, treatment, even experimentation and research, as we learn from the example that the chairman of Ngogo gave of the Pfizer issue that came up here in Kano. It is also an area where, according to commentators, information and knowledge is very limited at the general public level, but also even within the relevant professions of law and medicine. So I think that it is a well-chosen issue for this conference on legal practice, and it's important that we take time to address it. It serves the various purposes of this conference, where we want to improve our services as lawyers to the public, and also one of the objectives being promoting continuing education and exchanging information among us. So against this background, I welcome you all to this session. And I am going to, we have quite a good turnout of our panelists to discuss this issue. And some of the questions that I'm going to put to them to address will include what we really mean when we talk of informed consent in medical practice. What are the relevant laws and what's the legal framework within which this takes place? What are the rights and obligations that arise, and what are the challenges in practice? So let me begin. I thought that I should actually get those of our panelists who are doctors to begin to clarify what this means to doctors in the first place. In this regard, I have two doctors who are on the panel, and I also understand that Mohammed, who is on my left here, has been very much involved in practice in this area. So I'm going to crave the indulgence of the other panelists who are lawyers to begin with the doctors, especially offering my apology to a very senior lawyer who is with us here, the chairman of the ICPC, to give me the right to do this. So I'm going to call on Dr. Omar Garzali to please enlighten us on what doctors perceive to be informed consent and how this is practiced within the medical profession in Nigeria as a background to the discussions about the law. Thank you.
Thank you, Chairman of the Occasion, other members of the panel. I'm really glad to be here and to see this turnout. And when a learned colleague told me about this program, I told him that as a surgeon, as someone interested in transplantation and organ donation, I must make time to be here because I'm sure we remember what happened to former Deputy Senate President, issue of consent and all those things. Chief, he is part of this. Now, when we talk of consent as physicians, when we talk of consent and physician, that's a loaded question because most of our patients come to us, they will say, sir, do what you think is right. And we keep telling them that, no, madam, sir, I am not the patient. I am not going to operate on myself. You must know what is wrong with you, what is causing it, what are the treatment options. If I don't treat you, what will happen? They will keep telling you, sir, I don't want to hear all that. Just tell me. Just do what you think is right. So basically, when we come across an enlightened patient that is willing to listen to us, the first thing we do, we tell him about the disease. Sir, you have disease A, and disease A is caused by so-so and so-so and so-so. And this disease A can be treated by X, Y, and Z. In Nigeria, because that's one of the limitations we have, this X, Y, and Z may not all be available in Nigeria. In Nigeria, we have X and Y. If you want Z, you may have to travel outside the country. So it is important we tell the patient this because some people can't afford. And that Z is the best treatment option, but it's not available. So we also tell that. And one of the things we also tell them, that is if this disease is not treated, what is the natural history? Because some disease can resolve spontaneously. There are some particular lesions that if observed for 6 months to 2 years, they can just disappear on their own. So you must tell a patient that you say, no, I don't want to wait 2 years, remove it now. So that's a form of informed consent. Then another thing we have observed is there is some degree of partial consent. I don't know if you can use that term. Some of our patients come with two diseases that coexist. Someone has an injury on the head and he has a fracture on the hand. You say, doctor, treat the head, leave the hand. I'm going to traditional bone setter. I will tell them that, look, without treating the head cannot get better. You say, no, I don't, just treat the head and forget the hand. You make effort, but most of our people are adamant. They don't want anything to do. When it comes to hand, lower limb, they want to go to the traditional bone setter. Then one of the things, and that's what I'm happy you mentioned the Trovan trial in Pfizer, one of the things that most colleagues miss is the issue of complications. What are the problems associated with XYZ? What are those problems? You tell the patient about it so that he knows that, okay, X has minimal problem compared to Y, compared to Z. Okay, I'm choosing X. It may not be the best treatment option, but I'm happier with the complications that comes with it. And what are the treatment of those complications? So let me not take much of the time. That's briefly our understanding of consent and our practice. Thank you very much, Mr. Chairman, and other members of the panel.
Thank you very much, Dr. Omar. You're going to retain the microphone, Mohammed, and
I'm retaining.
From your own point of view, also, if you can move on the discussion because Dr. Omar has begun to talk about some of the issues and challenges that doctors face in this area. Would you like to say something about, he just described it as a very senior consultant doctor would do it. Is that the general practice, to your knowledge, in our hospitals and other health centers?
Okay. Thank you very much. Good morning, one and all. Pretty happy to be here. So I have a sore throat.
Oh, sorry.
I was coming from a hospital, actually. I gave a commitment to be here, and I thought it wise to keep it. And that's why I'm here. Well, he has said several things that I have reservations and misgivings about. In other words, I do not agree with what he has said, or some of what he has said. And with a specific reference to the fact that when patients come to a healthcare provider like himself, they explain to them about the conditions of their health, and then they give them the opportunity to decide. In other words, they comply with all the necessary protocols surrounding consent. I have a misgivings about that because the patients are getting sophisticated and it is no more a business as usual. If you carry out an inquiry or a survey, you'll be able to come to the realization that actually this is not what happens. Medical practitioners are actually blameworthy when it comes to actually ensuring compliance with the protocols surrounding consent. So that's one area that I have a reservation. Now, since we are interrogating the boundaries of consent, I think it is necessary to point out that the best way to properly interrogate the boundaries of consent is to look at it from the medical ethical principles and then the law. Now, the laws governing the issue of consent, of course, we have to make reference to the common law, the Code of Medical Ethics, the Hippocratic Oath, the human right dimension to it. Now, an informed consent is about an information, given to the patient describing the proposed medical procedure that is intended to be executed on him. So, now the general rule is that common law and our local legislation, a doctor or a healthcare provider is actually duty-bound to ensure that an informed consent is obtained before the commencement of any procedure, be it therapeutic or diagnostic. And that's where the problem comes. Sometimes half information is given, and sometimes zero information is given. And once that information is not actually obtained, the healthcare provider is being open or exposed to civil and criminal liability, and even a sanction from the regulatory body, talking about the medical and dental practitioners, disciplinary tribunal. So, in effect, the medical consent actually should be viewed from the perspective of the elements or the constituents that make a medical consent a valid one, because it's not every kind of consent that you gauge and call a valid consent. In the eyes of the law, the validity of the consent has to be tested from the provisions of the relevant laws. Section 21 of the Code of Medical Ethics is very clear on this. Though in our country, the laws are not expressly, making provision for an informed consent. But like the Prof said in the introduction, issues of privacy, issues of liberty, issues of issues bordering on religious beliefs and so on. They all, the issue concern depend largely on these issues, and they're constantly provided for. Even if you take a look at some of the conventions that Nigeria is signatory to, talking with reference to the United Nations Conventions, the African Charter on Human and People's Rights, you find that specific provisions are provided to that effect, that the human dignity, the human privacy must not actually be trampled upon. Otherwise, there is a human right dimension to that effect. And human rights issues are no longer a local affair. They are actually enforceable internationally. Here, there, and almost everywhere. So what I'm saying in effect is that the issue of consent is very sacrosanct. Its sacred nature had better not be toyed with, but what obtains actually on ground, speaking in all honesty with a sense of responsibility as well, what obtains is not compliance with the protocols governing the medical consent, because there are impeding practices, impeding factors, socioeconomic factors, because the economic recession that we're facing, or economic depression, or whatever, the poverty-stricken nature of some of the people accessing health care will always put them in a vulnerable state, because they are overwhelmed by the need for them to meet the financial obligations associated with accessing medical services. Now, at that moment in time, when the the religious issue too as well is another issue. You get to know about the Jehovah's Witnesses. They are averse and they abhor, blood transfusion. And most definitely, sometimes you find the case of the Okonkwo is very much very relevant and pertinent here, where the Supreme Court of this country say in no mistaken terms that generally a patient has a right to practice his own religious. Okay, I think I better hold on. I will expand more if I'm being asked questions further. Thank you.
Thank you very much, Mohammed. As we explore the challenges that come with this legal requirement, and I know that the doctors and the lawyers don't need to see it all from the same angle, but still, looking at practice before we come to the full consideration of the legal requirements, which Mohammed has already started discussion. I want to give the opportunity to another medical doctor who is with us online, and that is Dr. Charles Kojo, who also has done a lot of research in behavioral medicine, to give us the benefit of his experience and knowledge in how this legal requirement plays out generally in our hospitals. Dr. Kojo, are you with us?
Yes, I'm with you.
Yes, you have, because we cannot be sure of connection all the time. Can we give you some 10 minutes to address this issue? Thank you.
So this is a very important topic. Interrogating the language understand the contours and the nuances of consent. What does consent mean? The previous speaker, I followed the path because the service was a bit poor. What is consent and how is it obtained? Its implications for patient autonomy. And I think we also need to consider the subject of medical ethics, looking at it in a holistic manner. So consent basically really means total agreement for the performance of the procedure or surgery on the patient, for which adequate information must be given, including information on the risks
Thank you. Thank you. Thank you very much, Dr. Kaju, for giving us further enlightenment on this issue. Now I want to turn to our colleagues, the two additional lawyers on the team, and ask also for their own view. We have learned from what the doctors have told us, and additionally our colleague Mohammed, who seems to cross both lines, to understand that it's not as straightforward as one might think. There are practical difficulties in this area about knowledge, about awareness, about cultural differences, about communication. How does the law now address all these issues? Do we have sufficient clarity? If I may start with Chairman, will you allow me to start with Madam Joyce? If we can go to Mrs. Joyce Oseni to explain further about the strength and if there are weaknesses within the legal framework that we have currently in Nigeria. So far we have made reference to the professional ethics in the code for the doctors. What other laws in Nigeria impinge on this? And how would you assess the sufficiency of this legal framework for an issue that is so important to people's rights, people's life, in fact?
Thank you, Mr. Chairman. Consent, or informed consent, is the bedrock of medical practice. It is the concluding aspect of communication in medical practice. Every hospital, health facility is expected to develop a protocol on informed consent procedure. Such protocols are supposed to be drawn from both the statutory and institutional legal framework, thereby protecting the patient's right to informed consent. So we're going to talk about the National Health Act 2014. Section 23 of the National Health Act provides for a mandatory obligation on the part of the physicians to ensure that full knowledge is given to the patient. It goes further to explain the aspects of full knowledge, the status of the patient, diagnosis, prognosis, costs, alternative care, reminding the patient that he has a right to refuse such treatment, the implications of such refusal. So the full interrogating the boundaries of informed consent in this topic would have us x-ray the limitations and exceptions in line with the National Health Act. So we have the consent to surgery, especially in emergency cases, because in surgery you have both the booked surgery and the emergency surgery where you're not booked for it. So this goes further to say almost every hospital I am aware of has a surgery consent form you must sign. But the fact that a patient signs to that consent form does not make it, or does not make it an absolute proof that informed consent was applied. For example, I'm aware of a matter, but most matters don't go to court. So I'm aware of a situation in a public hospital in Kano State here, where a patient had given consent to donate his organ to his stepbrother. But on the day of the surgery, his mother, who is an estranged wife of his father, approached the hospital and said that consent that my son had given, in as much as an adult, was not fully given. Because consent must not just be given in that aspect. You must not be coerced. There must not be no duress, no promise and all that. So when you make such interruptions, you find out, if you look into the matter, you find out that that consent the guy gave, having signed the consent form, was not voluntarily given. So there's another one of, it happened in a situation where I am aware of, for a gynae case. A woman signed consent for cesarean section. And in the theater, the doctors had reason to remove her uterus. And issues arose, legal issues arose. We understood that the removal of that hysterectomy was not an emergency case. You would have just gone in, saved the baby, close up your opening, and book for the hysterectomy another day. So these are one of the limitations. Then you have the consent of a minor. Children below 18 years cannot give informed consent. This is where the parents come in. And the parents, by law, are not even meant to give consent. What they give is informed permission. Then this law has given the doctor or the physician a right to apply for state order where the parents' informed permission contradicts the patient's right to life. We have the Child Rights Act in this regard, Section 1 and 2, which talks about the best interest of the child, and Section 4 and 14 about the health and health services of the child. So where the patient, the healthcare provider feels that the reason why the parents are refusing such treatment is not for the best interest of the child, they go ahead. A 2019 Supreme Court case may interest us here. Is the case of Tega Esabuno and Faweya and another. The Supreme Court dismissed the appeal because it was actually appealed that the decision for the hospital to get a magistrate court order to enable them transfuse blood on their child was wrong. They contended that the magistrate court lacked jurisdiction for such order. But the Supreme Court held otherwise. As long as it's for the best interest of the child, they can give that order to show that the patient is saved. Consent procedures relating to incompetent adults or unconscious patients. Most times, incompetent adults are brought by the patient with their relatives or surrogates, and you're expected to make decisions for them. In that situation, you won't get the best consent to give because you're already biased. You don't even know how far to go or what they will do. So we are saying that the question you ask yourself is, this patient relative or surrogate that is giving this consent, has it done so in the best interest of this patient? This is where the advance directives comes in. Mr. Chairman here mentioned the advance directives based on religious beliefs. Advance directives is a legal document that empowers the healthcare provider to understand and execute the wish of the patient. So under advance directives, we have the direction to not transfuse blood. So you have the living will. This living will is accepted and known in Nigeria, but there's one that is not known yet in Nigeria, which we are of the opinion that should be considered, discussed, canvassed, and passed into law. That's the healthcare power of attorney, or the lasting power of attorney. Just the way we have in land. So a patient can decide that I want to appoint one or more attorneys to make decisions for me in the event I am incapacitated or I am unconscious. This, for me, it's a welcome idea because we have had situations, I work in a hospital, so we've had situations where patient relatives, maybe the brother of a patient, will come to the hospital and compel the patients to sign discharge against medical advice. But the wife of the patient knows that that is not the best best approach, but you have nothing to do because they are your in-laws. But where a patient prepares for this kind of scenario and appoints his wife or his wife and another person to act individually, independently, jointly or severally, it saves a lot of headache. It saves a lot of accusations for the wife and other family members. So we have consent by an illiterate person. Or barrier language is another thing. Barrier in communication. Section 23 of National Health Sub 2 puts a responsibility on the physician to give full knowledge, and please to do that in the language the patient understands. In the language the patient understands, also taking into cognizance the literacy level of that patient. So now how would you know the language the patient understands? It's not just about the medical semantics and the terms. There comes the interpreter, the resource person online mentioned the interpreter. We have in other jurisdictions something known as medical or healthcare interpreter. It is not provided for in the National Health Act. Mr. Chairman, I'm saying that the act is inadequate. The patient's relative may try to interpret, but we should understand that it breaches the duty of confidentiality or the patient's right to privacy. Take, for instance, a young girl with her mom who is being treated for a gynae case. And at some point, you need to let the doctor know what's up. Because for every right of a patient, there is a corresponding responsibility of that patient to give full disclosure. So where you've been treated for a gynae case, you need to disclose if you've ever had any reason to conduct an abortion. How do you expect a lady in the presence of her mother or her family members to tell you everything she had done prior to that visit? So this is where we need to ask for a review of the act because of its inadequacy. You also have consent to be given by a disabled patient. Yes, we have Persons Living with Disabilities Protection Act, but the National Health Act did not think further to consider patients who may be blind, who may be hard of hearing. So how do you do it? Yes, we know that some patients who are deaf may have family members that know how to talk with them, but that's not enough. This is where the auxiliary care comes in, the medical interpreter comes in. It will also help the system create more jobs for people. We have to consider medical interpreters in this part for disabled patients so that they will give us the full understanding of what they want. And in that way, the doctor will be able to give his best care to the patient. So we're talking about when a medical practitioner can fully withhold medical information from a patient. Section 23(1)(a) of the National Health Act 2014 talks about the full knowledge and places an exception to that. That exception can be referred to as a therapeutic privilege, where the doctor feels he has a strong conviction that full knowledge, when given, would affect the well-being of that patient. He is by law permitted to withhold information. For example, a patient being treated for depression, you know, there's a level of information you give to the patient and it becomes actively suicidal. Another exception is where the patient outrightly waives that right. We've been called on consult to tell us that this particular patient said he is not ready to know the outcome of investigation. We advise cancel documents. And the patient said, I don't want to know. Whatever you do, whatever you see, whatever the outcome of the medical laboratory investigations, the diagnostic investigations, please do not tell me. So by law, such is expected and should be respected too.
Thank you.
Thank you, sir.
Thank you very much. Thank you, Mrs. Oseni. Now, Chairman, would you like to come in now? We have talked about the medical challenges. We have now started from Mrs. Oseni's contribution to see that for lawyers, it's not also that all the issues have been settled in the law. Would you like to make further comment about this? taking that into the challenges that lawyers who are working or interested to work in this area, the challenges they face, and also what are the prospects that more intervention, more understanding from lawyers, what kind of benefit will it bring to the patients, and how can some of the challenges be addressed?
Thank you. Good morning. This topic is very important, and as a lawyer who I had participated in prosecution at the Medical and Dental Tribunal, so I had a kind of insight on the real issues. Now, the issue of consent is the issue of communication between a doctor and his patient, so that they will agree how, or the patient will now consent or give authorization for a medical doctor to carry surgery or procedure on him. Now, the main challenge which the medical doctors are facing is that, in my view, there is issue of even knowledge. Because when you interact with medical doctors, you find out some, they will not even ask you deeply, or they will not explain to you what are the issues which, if you undergo certain procedure, there are consequences. All they do, they will ask you certain questions, and they will give you drugs, or they will suggest what is the next step. And in some situation, the patient will come, like doctor said, do this thing for me. And some of them, because there is a case which I participated, and I know it's well known, whereby a patient, 2 kidneys were removed by a medical doctor. And I kept on asking myself, how can 2 kidneys of a patient be removed by a medical doctor? But when I interrogated further, I asked around the relation of the patient. Now I discovered that there is a belief in certain parts of this country that some people feel like if they have sickness, that you need to conduct surgery on them before they will feel okay. So maybe the patient came to the doctor, please conduct surgery on me because I have been having stomach ache. And I don't know, later on the 2 kidneys were removed and was handed over to the patient, which later he died, and the doctor was taken before the Medical Dental Tribunal. Now, this shows that there is a problem of knowledge, because even if you are not a medical doctor, an informed person knows that there is no way you can remove 2 kidneys of a patient and for that patient to survive. And there are 4 principles which guide the relationship between patient and a doctor when it comes to issue of consent, which I call them JAN. That is, first, the issue of autonomy. The patient has right over his body and mind. And the relationship between the doctor and patient, that's why the patient, because of the trust, he now gave his body and mind to the doctor so that he will conduct whatever procedure which will be beneficial to him. Because whatever a medical doctor will going to do is something that will be beneficial to the patient. It shouldn't be, there should be no malfeasance, something that will be hazardous to him. And also, the doctor should be just. And in this situation, there is need for the doctors to fully inform the patient. From what I read, 60 to 70% of Nigerians, when they go to hospital, like what doctor said, they will say, please doctor, do what is right. Do what you feel is okay. Because we don't interrogate. And I noticed that when you interrogate, there are some doctors, when you interrogate them, they feel not comfortable. When I go to hospital, before I go to hospital, I will search of any illness which I have. When I go to hospital, I don't keep quiet. I will ask the doctor, okay, this is what is happening to me. If I see him start writing, I will start asking him, I want to understand my problem first. If he explains, then I will interrogate further. If there are drugs which I know that I read that they have implication, I will ask. I have read that social drugs have effect. But the problem is that not most of us have that inquisitive mind to ask. When you ask, some will feel like you are trying to show that you know better than I do. Why? It's not like that, because it's better for that dialogue to take place so that whatever gray areas are, you will clear it. Most especially where you take your child to a doctor. At least he needs to explain to you because of that relationship between the son and the father. There was a time I took my daughter to hospital for tonsil surgery. When I asked the doctor, he just brought me a paper to sign. I said, please, doctor, explain to me what is the effect of this content. But because my daughter was in pain, I had to sign because she was in serious pain and she was convulsing. I had to sign. While they were conducting the surgery, I was here. After some minutes, I heard her crying. That the anesthesia has released her. She was crying. Maybe if he had explained to me that this is one of the issue which your daughter might have encountered in the course of the surgery. And also, when you look at the decision of the court, the Supreme Court and Court of Appeal, what they are saying, look, in issue of relationship between doctor and patient, the general rule is that once the patient is adult, he has control over his body and mind. Once he said, this is what I want, that's all. But now the question is, there are certain issues that are beyond that. For example, a housewife walked to a hospital and asked for an abortion. And she signed the consent form without her husband. Should the medical doctor conduct that abortion? What will be the effect if it was conducted and the husband discovered? So this is something which is tricky, because you can say the law said that an adult can give consent, but there is a situation whereby there is somebody who is a stakeholder and you need his consent. And also, there's a case which I read, the issue of even minor, where Supreme Court said, if the procedure is going to cause something which is irreversible, it's even tricky. Because in that case, Okereku versus Tanko, somebody had an injury on his finger. He went to hospital. He was 14-year-old. Then the doctors suggested that the finger should be cut off. And his aunt told the doctor, please, doctor, do what is right. What you feel is okay. And he did that. The doctor was sued. The matter went up to Supreme Court. Supreme Court said, no, since he is conscious and alert, and that surgery, which if what was conducted, it's going to cause irreversible damage, he must seek for the consent of that child, even though he's 14-year-old. So it is something which is not clear up to now, which the lawyers, all of lawyers that are in that area, most of all, we cling to the technicality which we used to in other sections of the law. That we don't look at the issue of the general principle, which is that you look at the interest of the patient and whether what was done to him is beneficial, and there was no malfeasance in what the doctor conducted. So we just feel like we'll just go there, argue law and argue law and argue law, which is beyond that. Because to me, it's not something that is law strictly. Because there are ethical issues, moral, And sometimes the doctors also face problem of religion. The issue of those who feel like, I will not take blood transfusion, like the case he cited. A 1-month-old boy baby was brought to hospital. The parents said that don't make blood transfusion because in our own belief, we don't believe in that. And also, we are afraid you may infect our child with HIV. But because the hospital, when I look at the hospital, it's a hospital which is manned or a reputable company in Nigeria. That was why they ran to court and obtained an order. Because maybe if they had not gone to court, if something happened to that boy, the same parent will turn around and say that they knew very well that our child will die without blood transfusion, but yet they do not conduct that. Thank you.
Thank you very much, Chairman. I understand that Mr. Godfrey Matthew is with us on to also address us online. So I'm now turning to Mr. Matthew to ask for his views on these issues that we are discussing. And since I understand that Mr. Matthew has background not only in law, but also in history, sociology, and theology, I think his intervention will be very useful when we discuss about some of these cultural challenges that come with this legal requirement. So your time, Mr. Matthew, for your contribution. Thank you. Mr. Matthew, are you with us? Oh, please unmute. You're probably muted. We can. Yeah, we can hear you now.
He was not
that person is grasping with it, must he follow all the process of consent? Must he obtain consent or what? In order to be right? So I think this is in our Lord should come, look at the situation like the other jurisdiction, who Samaritan should be like a soft pedal for Nigerian medical workers. If you also have the direct challenge, medical practitioners in also have a problem with consent. When you take a person that is short, about to die, and is gasping for their own head and see, sometimes they will be so debilitated that they may not be in a responsible capacity to give consent. Which was an unconscious situation. These are some of the dilemmas. They will have their cultural leader will say, don't do this to me. Under the military, he is bound to follow the first aspect. And I think that before we can look at the interface between medical and other professional bodies like military, the case of Olobo was very disruptive because it clearly shows that where there's a conflict between medical ethics and military ethics, the employer is also subjected to military ethics. So we have emergency situation in pure medical practice may have challenges when the medical practitioner is forced to other professions. Now, another thing that we also look at is the issue of pediatric consent. And I am happy that the last speaker talked about it, and my lady there, my colleague, she talked about the issue. You see, under Section 63, okay, of the 54th of the Natural Rights Act, 2003, it says that a consent for a child that is beyond the age of 16 to 18 should be obtained, provided it's mature living. And I think this principle may have drawn inspiration, might have drawn an inspiration from the Gili test conference. You know, what happened in one of the Commonwealth countries, that a child who is a small person, no matter how minor it is, how small it is in the eyes of the Lord, should be able to give a consent with the provided he is mature to know the consequences of his act. And if you look at our criminal law, that has to be according to the interhouse context. And that leads to also find reflection in the case of Dr. Kanko versus Chekiawa, where the court said that yes, even though the auntie thought that the child is a minor, she shouldn't go ahead and give consent until the child is, because he is in a capacity to understand the consequences of the treatment. So these are some of the issues that we're having challenges, and it's an area that I think we should be able to advance further. And what I think that we should is the issue of health emergency. To what extent? I think that medical consent is the navel of all principles of medical law. Medical consent is the navel of all topics in it. Because the purpose across from the consent from negligence, from pediatric complications, down to the essential issues, even to the regulatory that is in consent vital. And so, one of the things we look at is the connection between consent, for example, and medical negligence. My colleague talked about the provision of Section 23 of the National Convention. Explain the procedure, let you know all that is risk and benefit associated with the treatment. Then we have to get situations. We don't have a situation, we have a capacity to do so in a situation of emergency. We have a situation to do so where there is a problem of congestion. And we should remember that same doctor, it is a good that it will be held liable for a reason. Because one of the kind of negligence that the code of medical ethics, when there is what improper information, improper diagnosis, and something like that. So this is there's I think we should be able to bring our mind together and say yes, the Nigerian industry offer was the medical practitioners. Now another thing to look at in the public health crisis, we just keep on going. To what
Thank you. Thank you. Thank you, Mr. Matthew. Oh. Okay. Thank you. Thank you, Mr. Matthew. Mr. Matthew, thank you. Thank you, Mr. Matthew. Yes, thank you very much, Mr. Matthew. You have raised quite a number of issues. So as we round up, what I will do is, having given so much time, I think enough time to those who are joining us online to make their views known, I will now give, at the end of it, I will give a few minutes, maybe 2 minutes, 3 minutes to the panelists who are here so that we don't have to go back online again. In the meantime, let's also hear from members of the floor, comments and questions. We can take a few so that your questions and comments will be included in the response from the panelists. We can have up to
Mr. Chairman, sir, I have carefully listened to the submission made by the medical doctors.
Can you identify yourself first?
Okay.
And then name and where you come from, please, even though I do know.
Thank you, Mr. Chairman, sir. My name is Ado Malam Bello from Faculty of Law, Bayreuth University, Kano. Mr. Chairman, sir, as I've earlier said, I have heard the submission of medical doctors and my colleagues, the lawyers. My contribution is the issue of consent is very important. Which they have highlighted. But how do you explain to the other people who are going to write that they have consented? Mr. Chairman, I will give a practical example of my humble self. I had a surgery here. I was in Aminu Kano Teaching Hospital. They wanted to operate me. I was conscious. I filled the form. They asked me, who is going to sign for the consent? My son was very close to me. I kept mute. The people sitting there, they just told him, sign here. My son was about to sign. I asked him, do you understand what you are signing? He said, no. And nobody explained to you what you are signing? It's a very serious lacuna. I told him, you are signing the death warrant of your father. That's what I told him. He started shivering. He said, Baba, will not sign. I said, don't worry, sign. So now, the medical doctors, you owe a duty to explain whether in writing, verbally, whatever, any means of explanation of what consent is in law. Because even if a consent is signed, it will not exonerate you from negligence. The issue of negligence is there. Signature, consent will not exonerate you. Mr. Chairman, sir, that is an issue. The third point is reform. Several sections of the National Health Act were cited by my colleagues, the medical doctors, the lawyers here. It calls for reform. But our legislators are insensitive. They don't even know their responsibility. Mr. Chairman, sir, they are only there to share money among themselves. Mr. Chairman, you know me. I say it without mincing my words. Of what relevance is national anthem? Of what relevance is national anthem? They don't know Section 4 of the Constitution. They don't know their responsibility. They don't know why they are in the legislature. They don't know what they should do for this country.
Thank you very
Taking
much.
all the laws that have lapses
Thank
to look
you.
at them and reform them.
Thank you very much.
That is a very serious issue. Let them wake up. Otherwise, the general will take them up.
Thank you very much, madam. Thank you very much for your contribution.
Mr. Chairman, thank you for the opportunity. Mr. Chairman, I want to view it from a different angle. We are talking of consent. If we are talking about consent, we are making reference to the patients who have access to the medical doctors, while majority do not have access to the doctors. We are talking of the poor, who are the majority. We have public hospitals all over, at state, at federal level. But what is happening? Doctors, most of them, work for a few hours, maybe 3 hours maximum, starting from 10, then by 12 they have closed. And they are moving to their private hospitals, where they will get money. In fact, many of them, they are using the public hospitals to get the patients for their private hospitals. My concern is we, or the medical doctors and their association, they are showing like a lackadaisical attitude on this very important issue. Like lawyers, state council, once you give your consent to be employed as a state council, you cannot be part of the private practice. And that is why state council work and dedicate their time for the state. Medical doctors, they are behaving differently. They take salary from government. They go on strike for any sensitive issue, especially pecuniary in nature, but they don't care to work from morning to the closing hours. What medical and dental council or medical association are doing about this? And I think even MBA should take it as an issue, challenging the medical profession, challenging the association, mount more pressure on them. Since you are working for the public, working for the government, work full-time, not part-time, and do not take, I think it is unethical for a doctor to come to a hospital. In fact, they are using their supporting staff, mostly. Some medical doctors may not even talk to you that I have a hospital over there, but messengers. Sometimes, after you come out, they will tell you, if you go to that particular hospital, you will get it quickly. And this is the card. So this is my concern, Mr. Chairman.
Thank you very much. Before you sit, the rapporteurs want your name and...
My name is Ibrahim Mukhtar from Kano branch. Thank you.
Thank you. Yes.
We'll be given only 2 minutes for questions and comments. Thank you.
Well, this is the third on this side, so you've got to move to the other side.
Thank you very much, Mr. Chairman. My name is Aminu Sanigadanya, MNI. I'm of Kano branch. I'm also the chairman of local organizing committee of this conference. Mr. Chairman, may I commend all the panelists for a job well done. Mr. Chairman, my question is to the medical doctors in our mix. There is this tradition or a convention that whenever there is an accident, usually the victims are not usually attended by our hospitals until they bring police officers. Now we are all aware that there is this circular by the Inspector General of Police that all patients or victims should be treated immediately. That is the life first before all other issues. But still our hospitals of nowadays are still maintaining that procedure or convention of before attending any victim or patients, they must call for that police officer. To Dr. Garzali and others, please can you expatiate what is the reason behind all this is despite the circular? You are still maintaining that procedure as well.
Thank you. Thank you very much. I understand that we have pressure for time. Nonetheless, we have committed ourselves to 3 on that side. Can they be brief, please?
Good morning, everyone, especially the panelists. I congratulate you for this well-done job. But I have 1 or 2 comments to make. And I'm Zakia Haruna, and I'm from Yusuf Metamasila University. My comment is addressed to the Attorney General of Jigawa and also the former, and Chairman ICPC, and also the former Attorney General of Kano State, Mr. Ibrahim Mokhtar, who just spoke now. Yes, as you were saying, you were with your child at the hospital, and the doctor could not really explain the procedure that he was going to give to your daughter. And I feel very bad about that. But you know, I've had the privilege of growing up amongst doctors, and one of the complaints that they make is that the doctor-patient ratio is very bad. A single doctor, I can guarantee you, in Murtala Muhammad General Hospital can see about 200 patients in a day. So that what exhausts them and will not make them in a position to explain every detailed procedure that they would give to every patient when they have some patients waiting online without infrastructure on the floor, lying down without beds, rushing to treat the next patients because there are so many. And also, with respect to what Mr. Ibrahim Mokhtar also said here about doctors pursuing patients to their private hospital, that is very true. But also, having been privileged to be amongst doctors, I understand that most of this happens with the consultants. Yes, those of them that are growing in the profession who are not yet consultants or in their residency are the ones doing all the donkey work. So at some point in time, that is why what I'm saying would be true. A doctor can see up to 200 patients all by himself at a particular time from morning till afternoon till his shifts. And because also the environment is not very good, you will also have issues of negligence because medical doctors are generally understaffed, and usually the state government will not be in a position to employ more doctors. And myself and my colleague here, Huwaila, one time had the opportunity at the justice sector to deal with an issue of such nature in Murtala Muhammad Hospital, where a lady died while trying to give birth, and there was hullabaloo all over Kano State because the doctor was accused of negligence and he was even disengaged from work. We had to go back to deal with that issue from the justice sector because that particular doctor had many other responsibilities aside the hospital. He was taking care of the SAC, the Sexual Referral Centers, Waraka in Kano State, and he was the chief administrator. And he worked so hard, and because he was disengaged, there was nobody there to settle with the SAC. So that was how we got in.
Thank you very much.
Thank you very much.
Thank you for your comments.
Good morning, Mr. Chairman and members of the panel. My name is Suleiman Osman. Mine is just a question. I want the panel to determine the elements of consent for the purpose of reform and guidance, so that given the interplay of law, ethics, and morality, people would know in clear-cut terms what are those elements. That are they closed? Are they open? So that we will know what determines consent in clear and categorical terms.
Thank you very much. Thank you very much. Very important question.
Thank you, Mr. Chairman. My name is Obin Akbuchuku. I'm from the Onitsha branch of the MBA. I want us to look at consent from another perspective. Consent with respect to disclosure of medical record, where non-disclosure will affect the health of a third party. For example, where a husband or a wife is diagnosed of HIV and non-disclosure of his status is likely to lead to the infection of his or her spouse. Can we discuss consent vis-à-vis the provisions of Section 26 with respect to the confidentiality of medical record of a patient? Thank you.
Thank you very much. I think we have gotten the number of questions and comments. Most were comments. I know there was a bit of bashing of the doctors. So I was afraid when we come back here, the doctors may want to reply. But I also know that another lawyer defended the doctors. So we don't have to go back to that issue again. We can come back to the issues that are related to informed consent. And there are two questions that I hope one or other of the panelists will answer. One is about what constitutes the consent, and another one about the limits of confidentiality. So I have the four panelists, each with 2 minutes to round up if they want to address a question or they want to look at any of the challenges that have been mentioned and tell us of the way forward. There are so many of these challenges from the side of the doctors, from the side of the lawyers, and also the general public. So let me start with Dr. Ghazali to please.
Thank you, Mr. Chairman. Thank you for the comments and questions and contribution. Let me just address a question about the police, calling a police in case of accident. Now, that practice has been abolished. We have actually circulated a letter at the level of National Medical Association abolishing the practice. But in every profession, you have the good and not so good. So please, if you come across that, let us know so that we can educate that person. And if you find out they are repeat offenders, we actually address that issue. Then, Mr. Chairman, with your permission, the best I know, the legal profession is a profession of precision. Using our personal experience to not generalize, using the personal experience to say most colleagues are this and that does not sound so precise. So I'll urge our colleague to be watching how we generalize some issues. Then I want to, please, the aim of attending this conference is to have a clarity. Now, I worked in Murtala Muhammad Specialist Hospital Obstetrics and ONG department for 2 years. And there are two scenarios, because these are everyday scenarios, but I want the panel to address it. One, a lady coming with ruptured uterus. She was counseled that the uterus would be removed. But her husband is in query. She consented initially. Her husband is in query. He said, no, he'll come by 6 o'clock. That's when he will not give his consent. As a colleague mentioned that this, if you do the surgery, it will disrupt family structure. Because we have had cases of divorce. I know, I have divorced her. She didn't, you understand. So what does one do in that situation? That's one. Two, then in case of this, actually a colleague, she's a covered Jehovah's Witness. She needed a surgery that must require transfusion. During the consent, she agreed to the transfusion. But the surgery is a surgery we do awake. When we now came to the point of transfusion, she said, no, I am Jehovah's Witness. And we have started the surgery already. So what does one do in this scenario? So please, as we are rounding up, if you can address this issue, it will be appreciated. Thank you very much.
Thank you very much, Dr. Ghazali. You have also raised a question which I hope our professional colleagues, the lawyers, may also include addressing it in their final remarks. Mohammed?
Thank you. I'd like to thank you for raising all these beautiful questions. This goes to show your appreciation of medical law and medical ethics. Good to see you, sir, Mr. Bello. I appreciate your remarks. But I would like to point out that, you see, this whole thing has to be viewed holistically. Everybody has got to make contributions in their own rights. The lawyers have to develop interest in medical law. There is, a seeming negligible rate of lawyers developing interest in medical law. And of course, by extension, the lawyers like you, sir, need to be interested perpetually. I know you were interested in becoming the biggest politician in this country a couple of years ago, but it's like you have self-pedaled. You don't need to self-pedal. You've got to continue to pursue it in constant perpetuity. We need lawyers in the legislature. All those ad hoc committees, formulating policies around health, you need the input of the lawyers actually. And the lawyers will not be able to make ideal contributions unless, of course, they have the technical knowledge of the medical law. And that's why there's no gainsaying the fact that lawyers need to develop interest in medical law. It's a very interesting species of law because it intersects with all other areas of law, the intellectual property rights, law of taxation, corporate law, even labor relations, sir. So please, we need the lawyers to develop interest in this area. That's it. And the issue raised by Mr. Ibrahim Mukhtar, good to see you too. It's been a while. Well, you have to look at the issue of diversion of patients being perpetrated by some of the medical practices, especially the public hospitals. You have to be holistic in your view. You see, we have infrastructure deficit. There's no disputing that fact because it's palpable. You can see it. It's here, there, and almost everywhere. You don't have adequate tools. You don't have adequate manpower to run the hospitals and cater to the medical services of the healthcare recipients. The lady over there was talking about the overwhelming pressure on the doctors. So in such a situation, they're actually helping. I'm not trying to come up with a justification for diversion, no. I sit on ethics committee, health ethics committee, constituted by Kano State. We have had calls on a couple of occasions to deal with the issue of diversion. It is being perpetrated, but then if concerted efforts can be made and we can work collaboratively, I'm telling you, the end of that is within sight. Now, we need, okay, now let me round up by saying, all these issues kind of agitate one's mind. I wish we had more time because, anyway, I would like to say quickly that we need to mount a monster super duper, enlightenment campaign. You need to enlighten the general public. They need to acquire a higher status of sophistication. Yes, the former Jigawa Attorney General stated in the clearest of terms that before he goes to see a doctor, he conducts a research. But the research he conducted while going to see a doctor in respect of his daughter did not yield the much desired result, actually, because he should have stood his ground. You see, if we don't stand our ground in our relationship with the healthcare practitioners, they're going to be taking us for granted, and the deterioration will be perpetuated nonstop. So we need the legal reforms as well. We need the legislative branch, the judicial branch, need to actually come up with laws that will address the emerging issues, especially with reference to the technological development. We seem to be stagnating in comparison with what obtains in other jurisdictions. They're advancing, we're stagnating. Well, thank you. Thank you.
Yeah, thank you very much, Mohammed. I know you have been an advocate in this area, and the point that you made about the necessity for lawyers not only to be interested in this aspect of the law and other specialized aspect of the law, but also in the legislature. Since we started this conference, a lot has been said about the reluctance or non-response of the legislature. It's very important that in our advocacy, we reach out to the legislature, but also to our colleagues in the legislature. It makes a lot of difference if we engage them, if we reach out to them, if we bring them into our discussions. In my experience, I have seen it made a big difference when that is done. So the two minutes to, by the way, from now, I don't like anybody to say former Attorney General of Jigawa State, because it is confusing and ambiguous. There are two former Attorneys General of Jigawa State here. But now the chairman, I'm going to ask the chairman of the IPC to please make your final comment. And there's before us at least two questions that need to be addressed. One, in summary, what is it that constitutes this informed consent that we talk about, and is it well defined in the law? Between you and Joyce, please, if you can say a few words on that, and also secondly, the limits of confidentiality, so that we round up by satisfying those who ask those questions, but all of that still within the 2 minutes that each of you has. Thank you.
Thank you, Prof. When they say former Attorney General, they mean the newest former Attorney General. So, me, I want to talk about the way forward first. The way forward is that there is need for sensitization. Nigerians need to be informed. This issue of informed consent, what they need to know, so that whenever they go to hospital, this is what they are expected, the doctor expected to tell them, and this is what they are to do. And I agree that because of the pressure, the number of doctor-patient ratio is problematic. And also there is need, in my view, because health is very important. There is need to look at our educational curriculum. For lawyers, there is need for medical law courses in our universities and law school, so that people will be taught, so that they will know. Because most lawyers that are appearing before medical and dental tribunal, you will see that we only go there with their own notion of technicality, because we don't appreciate the concept of the medical ethics. So, and for the issue of what Dr. Ghazali raised, of that lady, is really tricky, which in my view, there is no way a patient can withdraw consent halfway while treatment has commenced. Once it commences, then as far as I'm concerned, he has waived his right. So for the issue of what constitutes consent is that the doctor needs to fully inform patient of what procedure he's going to undergo and the benefits and the risk, so that he will be able to take informed decision. So it's not something which is straightforward, like the case of Mo versus University of Regents. The United States Supreme Court said, look, you cannot determine whether the interaction between a medical doctor and patient that is informed consent. Sometimes it will even the court that will determine that, because it depends on the circumstance and the nature of the case. Thank you.
Okay, talking about emergency care, the law empowers hospitals to develop policies on how to operate health care services. In Alex Ekweme Federal University Teaching Hospital, Abakaliki in Ebonyi State, management of the hospital developed a policy on emergency care. No matter how bad or poor a patient may present his case, we don't bother asking for deposits or police reports until after 48 hours. What we are out for is to stabilize the patient. While we're doing that, we have the corporate communications department, we have the PRO protocol that liaises with the police state command, and they get the necessary documentation done. Then on medical advertisement and diversion of patients, yes, consultants, pardon me, are known for that because of their private clinics. But in making Nigeria better, we would say if you see something, you say something. In the medical field, it is actually a misconduct to divert your patients. So where you have such proof, because sometimes the patients may, on their own, accept that you treat them in your private clinic. But what do you expect a patient to say to you when you have advertised your skill and your services? Of course, they will accept. But when you have this information, we are advised that you report to the hospital management. If possible, talk to the doctor or go further to the professional body. So elements of valid consent, somebody talked about that. Capacity, the person has to have the capacity to make such competence. Yeah, we have issues. It's kind of technical because you see a patient who is in their need of having his life salvaged, or maybe an accident patient, and all he wants is for you to save the life. The patient doesn't even mind at that time to have his limbs amputated, but you need to ensure that the patient has that competence and the decision or the consent is given voluntarily. Talking about patient consent and confidentiality, even the Freedom of Information Act understands that patient consent or patient's record is very, very important. No matter how far or how the words of a lawyer, a letter for a lawyer comes to my desk to divulge hospital records of the patient, even if it's the insurance trust fund, I will let you know and cite to the authority there that the patient has to give consent for that information. Then because we know that it's technical and it affects the third party, this is a different aspect when it comes to public health issues. No. The doctor can decide to exercise his right to refuse treatment. Because for the patient to have a right to accept, the doctor also has a corresponding right to say, oh, I am not going to treat you. There have been times we have been told about this kind of scenario where the doctor will tell the patient, if you don't tell your husband, I will not treat you again. The only exception to this is emergency situations. And in this kind of situation, it's not an emergency. The patient is tested positive. So you can apply that right, exercise it, and threaten the patient. I am aware that some doctors have gone further to let the patient know that, let their spouse know that they have this ailment. But I would always try to rest on the side of caution. So Milord, please. On the aspect of the multiple languages spoken in Nigeria, it's a multilingual country. We also know that for different reasons, we have foreigners that come to access care. This is one of the reasons why we need to, in conversing for a review of the National Health Act, we talk about this medical interpreter. Then I am of the strong opinion that for a lawyer to take up a medical negligence case, I would say that maybe the MBA or the reform should try and make it kind of compulsory for the lawyer to have an experience or exposure, knowledge in medical law. Because lawyers are just out to make money. We know that patients are no longer interested in God gives, God takes, especially when it has to do with permanent deformity. But I had cause to read through a record of proceedings for over 600 pages, word for word. Damages of 50.2 million naira was awarded against the hospital. And I was worried that there is need to try and bring this in. We have elements that constitute medical negligence. How can you award such huge sum in a matter where the plaintiff, who is the patient, did not appear, did not give any evidence, there was no expert on the side of the patient, and you arrive at such damages. So in canvassing for this, there is need for retraining, training, advocacy, sensitization, and reform of the Act. Thank you.
Thank you very much, our very able panelists, not only enlightening us in this specialized area of practice and the law, including medical practice and legal practice, but also responding to the questions that have been raised. One of them about what constitutes consent, which has been explained, but I think maybe a reference for that is to say there have been good developments in the law. The learned SAN asked this question, and I think that a reference to two documents clarify the matter very well. The elements are, and Joyce and who came and made their contributions, those who barely can afford the time to spend with us here because of the pressure of their work. See, if we consider the urgency and importance of his mandate in the Nigeria of today, Mohammed, who is also from Ministry of Justice, Legal Drafting, who is also here with us. I thank you all for your contributions. Emphasis in the way forward has been that we lawyers need to do more to understand this area of the law and also to get some insight into medical practice for us to perform effectively and deliver excellent services to the public. Thank you very much.
Another good round of applause for the members of the panel. Thank you very much, Mr. Chairman and other members of the panel. Thank you. We are very much well enlightened with the submissions made this morning. Thank you very much. The next issue is group photographs, sir.
Just to mention that the plaques will be sent to you because we don't want to burden you with excess luggage, as we said yesterday. Let me specifically thank Abdullahi Muhammad, Director Legal Drafting Ministry of Justice, Kano. He's undergoing therapy and shouldn't be here, but his love for MBA, we're very grateful, sir. Thank you for making it.
May I quickly invite Her Worship, Honorable Salman Ahmad Dambapa, who would briefly, in 10 minutes, talk to us about punishment to prevention, a shift in focus for child justice system. Please put your hands together for Her Worship, Honorable Salman Ahmad Dambapa. Please, can you just, thank you. Thank you very much.